Good evening, everybody. Good evening. Gosh, how lovely to see everybody. Good evening and welcome to our iconic Shaw Library at LSE, which is really the heart of the LSE scholarly community and a really fitting venue for the third and final lecture in the 2025 Hamlyn Lecture Series. My name is Niamh Maloney. I'm a professor in the law school here, and it's a huge pride and a great pleasure to be here this evening to first of all reflect on the Hamlyn Lecture Series and then to introduce this year's Hamlyn Lecture, our very own Professor Dame Sarah Worthington. But before I do that, I have the very onerous task of being here for your comfort, but really for your safety. So if you look behind us, you will see the exit to this room. Just a quick note that we are recording this evening's event, and there is a photographer roaming around. If you'd rather not be photographed, just grab their attention and all will be well. So now, back to the serious business this evening. As many of you will know, the Hamlyn Lecture Series is a landmark in the intellectual life of the legal community in the UK and internationally. Each series of 3 lectures, and as you know, they're always published as a book, as the Hamlyn Lectures from that particular year, they each constitute an important staging post in how we think about and practice law, and so in how we reflect on the role of rules and the rule of law in ordering society. And there surely cannot be a more important endeavour for our legal community, as the very notion of the rule of law comes under increasing pressure. We are therefore much in the debt of the Hamlyn Trust, created by Miss Emma Hamlyn in, it is thought, in honour of her father. William Bussell Hamlyn of Torquay was a solicitor, a commissioner for oaths, including for Nova Scotia, something I found fascinating. He was also a justice of the peace and very prominent in the civic life of Torquay. Emma, his only child, who died in 1941, was clearly a remarkable woman, independent-minded and public-spirited, and with, it seems, a great interest in law, although she wasn't a lawyer. Now, in her will, and so we're told, in terms that were her own, and also apparently resisting all attempts by her solicitors to amend those terms, and I love that detail about Emma, she bequeathed the residue of her estate to her executors as trustees. And the terms of the trust, I think, are really worth repeating. So it was upon trust to apply the income of the trust fund in the furtherance, by lectures or otherwise, among the common people of this country, of the knowledge of the comparative jurisprudence and the ethnology of the chief European countries, including our own, and the circumstances of the growth of such jurisprudence, to the intent that the common people of our country may realise the privileges which, in law and custom, they enjoy in comparison with other European peoples. I make no comment. And realising and appreciating such privileges may recognise the responsibilities and obligations attaching to them. Now, I do think these directions resonate down the years. The notion of understanding the rights, privileges, responsibilities and obligations under the law, some 84 years after Emma created this bequest. Emma's solicitors, though, urged her to revise this passage. They felt the words were overly vague. The main issue being that the object of the trust, the common people of this country, was too wide and uncertain a class, and the bequest might therefore be void for uncertainty. Now, sure enough, litigation duly ensued, but happily for us, the High Court in 1948 approved a scheme for the administration of the trust, including with country being taken to mean the United Kingdom. Now, the first series of Hamlyn Lectures, as I think is well known, was on the theme of freedom under the law, and was delivered at London University, just over the way in Senate House, by Lord Denning in 1949. Since then, a series of magisterial lectures on fundamental questions of law have followed by the most distinguished scholars, judges, and practitioners of law. The Hamlyn Lectures really now are a canonical resource on how to think about law. The Hamlyn Lectures by tradition are held in autumn and in different venues. So this year's lecturer, Sarah, has been on a scholarly journey that started 2 weeks ago, I think, in Edinburgh, then last week in Cambridge, and to our great pride, concluding here this evening at LSE, which we do claim as Sarah's home. And we're very grateful to the Hamlyn Trust for enabling the law school to host this most important event in the legal life of the UK this evening. Now, trying to capture the sum of Dame Sarah's, and Sarah, as you know, was awarded a DBE in 2020 for services to private law. Trying to capture her achievements really is a daunting task, and it's all the more so, Sarah, because I have the immense professional and personal pleasure of being a colleague of Sarah's. So I have direct and exact knowledge of how fantastic she is and how generous a colleague she is. And I still remember, Sarah, that slightly awestruck feeling when I met you when I joined LSE back in 2009. And my anxiety was not helped because my first job at LSE was to teach company law. And I was heavily reliant on Sarah's work, including the utterly indispensable and elegantly written Gower's Principles of Modern Company Law. A Fellow of the British Academy, an Honorary KC, a Bencher Middle Temple, among many distinctions, Sarah was a professor here at LSE and also a Pro-Vice-Chancellor, before being appointed to the Downing Professorship of the Laws of England at the University of Cambridge, a chair which she held for 11 years, and over which time Sarah co-founded and directed the Cambridge Private Law Centre. Alongside, Sarah's contribution to public life is immense, including her current trusteeship of the British Museum, but also her tireless work in law reform. Sarah's magnificent corpus of work spans commercial equity, personal property, and company law. In each of these fields, and unusually, because the Academy increasingly tends to specialisation, but in each of these fields, her contribution has been definitive. Sarah's research, in short sum, is primarily focused on controversial issues relating either to personal property rights or to abuse of power in commercial, not-for-profit, and corporate contexts. And these are big, difficult, and important questions. We were delighted to lure Sarah back to LSE in 2022 as a professor, and we're thrilled that she is now chair of LSE Press, and so shaping scholarship across LSE. Now, Sarah's theme for her Hamlyn lectures and the subsequent book is a large one: the paradoxes of property law, from castles and contracts to information and ideas. Sarah asks, and with typical intellectual fearlessness, what is protected under the rubric of property? And why is this special form of protection provided in some contexts but withheld in others? As Sarah notes, the framework of property law stands as a particularly powerful legal and normative institution. And Sarah's purpose with this year's lectures is no less than to determine whether the current architecture of property law is capable of responding adequately to increasingly strident modern demands concerning the allocation and protection of new and newly valued modern resources. And in this final lecture, Sarah asks whether our legal conception of property, notwithstanding its sophistication, is adequate to meet the challenges of the 21st century. Now, I suspect all of us here this evening can think of examples where Sarah's question is an urgent one. As someone who works in financial markets, I think of the intense gyrations of stock markets globally over the last couple of days relating to AI, and of how AI is placing pressure on how we think about property rights in information and ideas. I think of the explosion and potential bubble in crypto assets and the myriad issues of property rights that they continue to provoke. And as governments increasingly press on households to save through the financial markets and invest in shares, including to support growth, I think of how property rights and securities are held and transferred, and how we still don't have full clarity on the law here, in particular transnationally. Now, I'm not sure what Emma Hamlyn would have made of these issues at the time she made her bequest, but I do feel sure she would have been delighted that this year's Hamlyn lectures promise to unlock some of the mysteries of how property law can adjust to changing conceptions of property and to increasingly intricate property right allocation questions. I also feel sure that we in this room, the objects of Emma's generous bequest, will learn a great deal tonight from Sarah's probing of the nature of property law. So Sarah, it's my huge pleasure to invite you to give your third and final lecture, and we'll have a little bit of time towards the end for questions from Sarah. So, Sarah.
Well, of course, it's an honour and a privilege to be invited to give these Hamlyn lectures, but it's also pretty daunting, and Neve just makes it all the more daunting. Of course, the topic I picked before I had put pen to paper at all is impossible, isn't it? But I can at least nibble round the edges of it, and that's what I've tried to do in these 3 lectures, and I hope to expand on that in the book that will follow. First of all, thank you, Neve. mean, you've raised expectations way beyond what I can possibly meet. But Neve is my ideal academic. I mean, she says was a little in awe when she first met me, but Neve is an academic whose personal style and her intellectual caliber are displayed impressively, not only across every sort of job you can have in academia, but also outside in the real world. And so I was thrilled you agreed to chair it. Thank you. Thank you too to the Hamlyn trustees, 3 of whom are here, and to Giuseppe and Alexandra at the LSE, who've been wonderful to work with in organising this. I especially wanted to give this last lecture at the LSE because it's home. Neve is absolutely right. I think I first heard of the LSE when I was a teenager, and it remains the terrifically exciting place that it was in my imagination way back then. It's been formative for my research and my teaching, but also for the warmth of the friendships forged and the collegiality of both colleagues and students, and most of all, I think, for the intellectual exhilaration that just seems to ooze out of its walls. So, thank you everyone who made tonight and it happening here possible. But let's begin. These 3 Hamlyn lectures which this is the last, form a single argument about property, but I appreciate that most of you will only hear this one. That means I need to give you some idea of the shape of the whole so that you can see what part this lecture plays within it. In Edinburgh and Cambridge, I considered what it means to own something and what we do and what we can own. And I want to give you an overview that I hope will enable us to move on from there. But first of all, I chose property as my Hamlyn subject because property touches everyone, and it's where the law's protection feels strongest. We all own property, and the catch cry is that it's good against the world. And I guess it's that potent sense of power plus protection that lies behind the current clamouring for all manner of valuable resources to be labelled as property. So personal data, body parts, crypto assets, privacy rights, image rights, and on and on. But in my first lecture, I majored on the idea that simply labelling something as property tells us next to nothing about the detail of the consequences which follow. Indeed, in some senses, it's even less informative than saying, this is a person. Now I can tell you everything about the legal consequences that will apply. It's true we have precedents to guide us, but the interplay of the facts and the legal rules is complex. The messy truth is that what happens in any concrete dispute depends crucially on the particular type of asset, the detailed factual context, the particular relationship between the parties, precise nature of the interference, and any relevant legal or regulatory framework, other things besides. Sometimes liability is strict, sometimes it's fault-based. The remedial results can shift radically depending on the status of the person harmed, who caused the harm, what relationship they had with the claimant, what role they occupied, exactly how they benefit, and what interest society has deemed as needing protection and how. And so, in short, sticking a property label on some valuable resource is not a substitute, it's not a proxy for all the hard policy work that must still be done by someone to fashion a workable legal framework for such a property interest, whether that someone is the courts or the legislature. And further, in doing that hard policy work, the red thread running through my 3 lectures has been that as lawyers, we've focused far too much on the rights of owners and the obligations owed to us by the rest of the world, and far too little on the responsibilities or the liabilities or the restrictions or the obligations that might accompany those rights. So in that sense, I suppose these lectures depart from my usual doctrinal focus, which, at least when I look backwards, I don't think I thought this at the time, has had a sort of unrelenting rule of law focus. I've concentrated on the incidence of legal and equitable interests, especially equitable interests, but the scope and the scale of their protection. And my sole goal, most of the time, has been, on endless repeat, to argue for coherence and consistency in our rules so that we can be confident that like cases are being treated like. But in these Hamlyn lectures, I wanted to step back and ask a still broader question. What's the entire framework of property law for? And what might we be missing in looking at it? Now, we already accept that all ownership is limited. I can't drive my car as I please. I can't demolish a listed building simply because it's mine. And moreover, those restrictions or those limits exist not to protect me, the property owner, but to protect other individuals or the common good. Yet our legal architecture still centres on owners' entitlements, with far less attention given to restraints or responsibilities that ownership invariably brings. So the central idea of these lectures is this. Property law exists to protect valuable resources for the benefit of society. That protection necessarily involves both rights and duties. If we think of property only in two dimensions, rights of owners, the obligations owed by the rest of the world, we miss the third dimension, the public purpose that justifies ownership at all, and the corresponding responsibilities and obligations that may flow from the owner to the rest of the world. So what I'm hoping is that at the end of these lectures, at the end, but certainly at the end of the book, we can begin to appreciate a more complex but a more complete three-dimensional conception of property, one that balances entitlement against responsibility and sees ownership not simply as a bundle of rights, but also with a complex overlay of responsibility. Not necessarily a neat picture, but I think it's a far more accurate and focused one than making assumptions that a property label will deliver all the answers to some very difficult questions. So now this lecture, as Niamh said, my focus is on whether our ideas of ownership are fit for the 21st century. Of course, that's a huge question. But I want to engage tonight just with two aspects of it. First of all, are we able to decide what is property and what is not property? We're going to have this architecture about property. We have to know what's in the property box and what's outside it. Can we make that decision? And secondly, having decided that some resource should be managed under the property regime, not outside it, do we have the proper tools in the property toolkit to protect those valuable resources in a way that delivers the desired ends? I'm going to spend more time on the first of those questions than on the second, partly because it's easier to do in a lecture. The second is really quite complex. And in looking at that first question, I want to look at both the generalities of what we can own and the fascination of crypto, though I will get to crypto. But in the book, the balance will be reversed. I'll spend much more time on the overarching and layered structure of responsibilities. So, before we tackle either of those questions, we need some shared understanding of the territory. I've already given you the complexity punchline from my first lecture with its message that the property label can't possibly do the job we sometimes demand of it. But nevertheless, we do have a property box, and a complex one, and it's important to decide what things or assets or resources should go into it, even if the entitlement and the obligation consequences of that allocation are diverse. Now, when you're thinking about whether something could possibly be property, it's necessary to have some view of the essential characteristics of property. And Honoré's 1961 description of the 11 incidents of property has earned its reputation as a classic introduction. Those 11 incidents are often used by commentators, not by Honoré, to define property and to decide whether some asset or resource is or could be property. I don't think that's the right starting point. Instead, what I've done is certainly use Honoré's 11 incidents, but taken from those 3 core incidents not to use as definitions, but instead to use them simply as structured markers or a useful framework for discussion of the property territory. And my idiosyncratic 3, I suppose, are the possibilities in any property regime of exclusive use and enjoyment of the resource we're talking about, an ability to transfer it, and the liability to the imposition of obligations, liabilities, restrictions for the public good. Historically, as I've just said, the first two of those incidents have attracted the most legal attention. But all our precedents reveal that neither of those first 2 incidents is ever invariably absolute. And the third incident, the obligational side, is there for me in those top 3 markers to indicate that inevitable qualification and to provide the deliberate link to my red thread in these lectures. In short, that 3-way division that I've picked out of Honoré's characteristics as the possible property incidents indicates and is intended to force a more structured discussion of the potential use of each of those incidents as levers to deliver policy ends for the public common good. So, if Honoré's 11 incidents don't describe and define what can be property, then what does? And last week in Cambridge, I sought to establish that the acid test for whether something can be property is excludability. That, I think, is the only absolute requirement. But even when a resource does have that quality, there's a further question. Should the resource be classed as property, or should it be unowned by anyone? Sometimes those can and should questions are wrapped up together by insisting that excludability is assessed not only by factual or physical concerns, but also by legal or moral concern. And I'm going to use those 3 analytical routes, but whichever way this is approached, it's important to remember that there is a normative decision to be made about whether something should be property, even if, in every other regard, it could be property. Put another way, I suppose, a decision that something is property is not a value-neutral category. It embodies a decision about what we value and how power over those valuable resources should be allocated and restrained. But before any of that allocation of rights and restraints can be discussed, the property framework requires there must be something that's capable of being owned. The asset must exist as a distinct and separable thing, something that's not me, so it's not embraced by the protection of me as a person, something that can be identified, controlled, enjoyed by me to the exclusion of others, at least to the fullest extent allowed by the law, reiterate my inevitable obligations and responsibilities theme. In short, the resource must have the possibility of excludability, or as it's increasingly described, it must be rivalrous. My enjoyment must diminish if yours begins. Neither of them are very attractive words, are they? But haven't thought of any more. There are endless examples of this test of excludability in operation across factual, legal, and moral domains. And for now, what I want to do is just gallop through a few illustrations so that you can get a feel for the territory. If you take physical or factual limits on excludability, information is the classic example of an asset that fails the excludability or the rivalrousness test. That remains true no matter how valuable the information is. If information travels, you have it and you can pass it on to others, voluntarily or involuntarily, without losing it yourself. Information can still be protected, but by rules that regulate conduct and relationships, by obligations relating to confidentiality, contract, data protection, insider trading, trade secrets, but not by granting ownership. If we move from the physical question of excludability to the legal one, I want us to notice that the legislature can take something that's not naturally excludable and make some subset of that resource excludable property, provided it's boxed in, marked out in a way that notes to the rest of the world the owner's exclusive entitlements. And again, information is just such a resource. Intellectual property is the paradigm example, isn't it? A statute defines the subject matter, grants the owner limited term exclusivity to use and enjoy and transfer the resource, and indeed supplies remedies for interference that are far more muscular than those available for tangible assets. And all those elements that are put together in the intellectual property statutes are deliberate design choices. The law is not merely recognizing that something that might naturally be property, but is constructing property for particular policy reasons. In the intellectual property domain, we typically say it's motivated by a careful balancing of private and public benefit. But then there are other examples of legally constructed excludability. I think contract rights such as debts and shares and bonds are by their nature, by their essential legal characteristics, also excludable assets. And equally, the law can declare something which is physically and factually excludable to be a resource that is not subject to all the incidents of private property. So, for example, with illegal drugs, it's illegal to possess them, to use them, to transfer them. They are not even subject to the distribution regimes which operate on insolvency or divorce or under the proceeds of crime, except by way of seizure and destruction. So, physical or factual limits, legal limits. If I turn to moral limits, it's obvious that just as the law can create excludability where none existed, it can, and indeed it does, deny property status even where physically excludability is entirely feasible. The most familiar example is body parts. There's no physical impediment to treating body parts in just the same way as we treat other chattels, yet English law has long refused to do that. The refusal is sometimes expressed as a rule that there's no property in a human body, but even the limited common law exceptions to that rule seem to reflect a deep moral instinct that the human body should not be commodified. That same sort of approach is repeated in the Human Tissue Act and the Human Fertilization and Embryology Act. These statutes do not allocate ownership. The body parts may be used, but only in limited ways for limited purposes, with these all defined and circumscribed by requirements for consent and licensing and compliance with statutory and regulatory duties, all achieved without allocating ownership. And I think the lesson I want you to take from that gallop through excludability are pretty straightforward. Even where physical control is possible, moral or legal constraints may prevent a resource from being treated as private property, or it may require it to be treated as private property. And even where something is classified as property, it may carry only limited rights to use or transfer, coupled with significant obligations or restrictions. But notice one further crucial point. A conclusion that something is not property doesn't leave that resource or us unprotected. Indeed, often the reverse is true. Many familiar non-proprietary resources, non-private ownership property resources, like water in the rivers or the sea or most body parts or our personal data, are subject to some of the most stringent controls in our legal system. And these examples illustrate a consistent reluctance to convert every valuable resource into privately owned property. They also demonstrate that some of our most valuable resources can be governed more effectively, not through proprietary dominion and rights of ownership, but through some sort of regulatory stewardship, not rights of control like owners have, but obligations to control, so that the resource is used only in limited ways and only for limited purposes. These laws shape the duties that are owed to others, often to the community at large, and they do that without conferring or conceding to individuals property rights in the resource that are good against the world. In short, the boundary between property and not property is not a boundary that between protected and unprotected. And if I combine the insights from my last two lectures, whether something's classed as property and what that status entails depends not only on its factual characteristics and its capacity for excludability, but also on the legal architecture we choose to build around it, the interests we prioritize, the duties we impose, and the balance we strike between private benefit and public good. But now we need to see if all that generality can be applied to a real problem. It's the acid test, isn't it? We need a concrete case. Because Emily is here, I think maybe the hardest concrete case is brain organoids, human organoids. I mean, if we're going to start building people in laboratories, this is going to be a real issue for private ownership. But I'm picking crypto, much easier by comparison. What I want to know about crypto is, do we have the tools to decide whether it is property or not? Now, for those of you who've remained completely out of the loop on crypto assets and Bitcoin and all its variants, you no doubt need a definition of what Bitcoin is. I want to take a light-hearted approach to this. By taking a definition which appeared in yesterday's FT. The FT definition, Bitcoin is a digital currency. That sort of sounds important, doesn't it? Sounds like electronic money, very FT-ish. But in one of the replies in the comments underneath this particular article, the comment was this: not currency, not an asset, not an investment, not a store of wealth, not anything really, digital pet rocks. I thought that might be Rob Stevens, but I think he thinks there's not even a rock there. But that does at least give you a sense of the distance between those who think we're talking about important items of property and those who don't. But what I want to do is see if we can approach this as lawyers. Crypto assets exist in the world, in some sense, without a law needing to construct them first. So in that sense, they're like cars and coats and horses and houses. And so the instinctive view is that if they're used and useful and valuable to those who are using them, then perhaps they can and should be classed as property. Yet we've just seen that the doctrinal analysis turns out to be harder than expected for just those sorts of assets that exist in the real world, and perhaps easier for assets that exist only because the law has created them. For crypto, we have none of the scaffolding of a legal creation of an asset, so the could and should property questions have to be approached from first principles. So what I want to do is try and capture the attractions and the difficulties of that exercise and try and do it fairly, but without disappearing into the technical weeds. So first of all, the question, can crypto assets be property and should they be? In England, Parliament is not going to answer either of those questions. The Law Commission proposes that the English law, new legislation, should simply provide that a thing is not prevented from being an object of personal property rights merely because it is neither a thing in possession nor a thing in action. Very strange statute. This negative formulation doesn't tell us that crypto is property. It merely confirms that property in English law is not exhausted by shows as in action and shows as in possession. We already knew that, didn't we? Intellectual property, milk quotas, etc. So all the real work on whether any given crypto token is property and what consequences follow will be left to the courts. Scotland has taken the opposite approach. It proposes to declare certain crypto assets to be property and then to sketch a legislative framework for control, transfer, and good faith acquisition. It still leaves the detail to the courts, but at least it's starting from a firm legislative assertion of property status. So, to our question. What exactly are we talking about with these crypto assets? I want to focus tonight only on the most controversial end of this classification problem, and that concerns pure crypto assets like Bitcoin, which are not backed by any claim to some underlying identifiable property. So they're not the sort of assets which simply use blockchain technology as the sort of plumbing infrastructure for an underlying recognizable legal asset. Because when you use blockchain to record a share or a currency balance or a contractual entitlement, the legal focus is all on the currency or the share or the contractual entitlement. The blockchain is simply infrastructure, just as Crest is for shares or a bank's internal IT system is for deposits. We don't usually bother about whether that's property or not. But with pure crypto, there is no underlying legal claim. The value is conferred entirely by the willingness of the participants in the club to accept the crypto token as a currency or an investment. And in that sense, probably shot for this, but in that sense, it seems to me it's the digital equivalent of blue beads. And indeed, blue beads designed precisely to operate outside any national legal regime. Notwithstanding that, the vocabulary that's used with these assets is deliberately deterministic. Bitcoin, cryptocurrency, digital assets. The labels invite us to assume a proprietary status at the outset. Nobody describes these things as consensus entries on a shared database or privately held update credentials, although that description seems to me to be perhaps closer to the reality. So I think I've already let out my uncertainty about these assets. But I want to explain the dominant argument, and it is a dominant argument, both nationally and internationally, that these assets are property. I want to explain what that argument is as best I can. These crypto assets are obviously intangible, but they're not claimed. They don't exist because the law recognizes a right against any person. They exist regardless of a legal regime. And the thing that exists is a specific pattern of data on a distributed ledger and a network that will record transactions that are signed with the relevant private key. So that asset would exist whether or not English law took any notice of it. And on that description, crypto assets could meet the excludability test for property. They're identifiable. They can be found at a defined address or output on the ledger. They're excludable. Only someone with the private key can cause the system to recognize a transfer. And they're rivalrous in the sense that once A validly transfers control to B, A can't reverse or replicate that transfer of control. So a pure crypto asset is not simply information in the abstract. It's not simply a long string of numbers identifying the electronic record, which would be non-rivalrous and normally not property. But it's the combination of the specific electronic record and the system which renders that record the object of a uniquely exercisable power. So some commentators have put it like this. The asset is the electronic record which can be subject to control because of the operation of the system. So it's the data record that's then made specific, excludable, and transferable. And English courts have certainly made the move to accept such assets as property. You see cases where proprietary injunctions have been ordered. Crypto has been said to be capable of being the subject of a constructive trust and spoken of as the object of property rights. Yet the explanation, it seems to me, does have a serious gap. When we call something property, we usually mean there is a something, there is a thing to which the owner's property rights attach. Possession or control helps identify the owner, but it doesn't usually define the thing that's owned. With a chattel, the thing is obvious. With a debt, it's the legal claim. With copyright, it's the statute-protected expressive form. But with pure crypto, the candidate for the thing begins to look like nothing more than the exclusive protocol-defined power to cause a system to alter a ledger entry. So the private key is a credential, not the asset. The ledger entry is data, not the asset. But the asset is the ensemble of powers that attach the control of the entry within the consensus system. I think that's what leads to Rob Stevens' worry. If the key doesn't open onto something, what are we saying is owned? At least, I suppose, with a locked garage, you might infer that there's a vehicle inside. Here, the garage, the exclusion mechanism, so not even a garage actually, the exclusion mechanism may be all there is. And that becomes acute or obvious when we discuss transfer. No thing is in fact transferred. A's asset, however we conceptualize it, is destroyed, and B gets a newly created, differently numbered electronic record. So, on one view, A's not sold an object to B, but sold a place in the game, and B has bought entry to the game. So crypto tokens then begin to look less like property and more like a relational construct maintained by a technological consensus, which is very close to saying it's a membership in a rule-governed game whose tokens function as blue beads within that community. They have value only because others in the club agree to treat them as valuable. And indeed, you've got to say that's how the crypto market functions. So that's my skepticism. But I have a further sense of unease in just roundly saying that these crypto assets, and I mean the ones not backed by any rights, I have a further unease about saying that they're property, putting the label on them, because these assets were designed specifically to operate outside national legal systems. They were designed to be anonymous, untraceable, operating without reliance on state-backed rules or state-backed value. And indeed, they were designed to operate outside any limitations that might otherwise be imposed by anyone's national rules. And so to declare that our legal order would nevertheless domesticate that internal club's token as full legal property, quite a striking move. Though, as I'll note shortly, it's perhaps necessary for insolvency and proceeds of crime purposes. So, there's an argument that crypto can be property. Should it be property? The arguments for saying it's property are the participants treat these tokens as assets, owners expect them to be given the protection of the law, and we certainly want them squarely within the regimes that operate in proceedings relating to insolvency or divorce or proceeds of crime seizures. And I would agree that whatever Bitcoin or blue beads turn out to be, they should be amenable to seizure or division in those latter contexts. But that seems to me very different from giving full property protection to the enjoyment, the transfer, and the vindication of rights between speculators. It would be using the law to protect an asset that's been deliberately engineered to evade legal orders. And that has something of a heads I win, tails you lose feel about it. So in that context, I might go back to my 3 strands of property possibilities that I took from Honoré and suggest that rights under the first 2 heads of those strands need not be a major concern here, even if the third obligational side is. I'm going to skip the other issues that people raise about, even if we said these things are property, then we have lots of difficult legal questions that the judges will have to face on what analogies will there be with conversion? Could you possibly follow these assets? I don't think so, since the new numbers get generated every time. There's no possibility of chasing my red sports car through all the transactions and suing each party in conversion. Tracing too is going to be extraordinarily difficult when anonymity and secrecy is designed into the system. And what's the situs of these assets when a distributed ledger is described as nowhere and everywhere? How then do we pick the site for choice of law, for tax, and for enforcement rules? How do you freeze these assets? The list goes on and on. So I suppose, where does that leave us? I accept that crypto assets could be analysed as property. I also accept that in any event, the legislature could simply declare that crypto assets are property, cutting through all this debate completely. However, I do suggest that the mere control explanation of the thing, where control seems to be the thing, hides a real tension. And we should not automatically conclude that crypto should be property, especially for all purposes. So I think we do have the doctrinal tools to decide whether a resource can and should be classed as property. Clearly, not everyone's going to agree on the answer that will be given in respect of any given resource. I want to leave crypto there, and can we decide what's property or not? I think all the hard questions in front of us are really, really hard questions about whether something could be property, but even harder about whether some of these things should be property. And I mean that more particularly when we're talking about AI-produced assets, when we're talking about what we do in laboratories with human body parts and what we can create, as well as things like crypto assets, but that is the easier end of these difficult problems. But if we could decide that something is property, then my final question, what do our property laws need to be able to do to be fit for the 21st century? We have got an astonishingly elaborate property toolkit. It provides for all sorts of different derivative interests in property, different rights and obligations of property owners, different consequences for different infringements, and all of that has an overlay of different regulatory controls governing conditions of ownership, regulating use of different important resources, imposing layers of planning, environmental controls, financial conduct controls, consumer regulation, and on and on and on. And so the problem, it seems to me, is not lack of tools, but lack of clarity about three basic questions. What are we trying to protect? Some of that I've done. Who should hold the key entitlements? There is property. And what burdens ought to accompany those entitlements? I think too often we dive straight into the doctrinal detail and lose sight of the wood for the trees. Probably what I've just done in focusing on crypto. But sometimes turning something into property is precisely what we want. It can provide incentives to invest, to improve the asset, to make resources more productive. But at other times, the goal of conservation or restraint, for example, in relation to climate, biodiversity, cultural heritage, suggests that things should not be property, maybe at all, or should not be property subject to private ownership. So if I split these big questions into something manageable for what remains of this lecture, why have property at all? What choices follow? And how do we deal with the obligation side? I just want to say something under each of those heads. On the why have property at all, none of this complexity of rules and regulations makes sense at all unless we remind ourselves why we have property in the first place. Property takes resources out of a common pool and vests exclusive control in some people rather than others. Proudhon's property is theft is no doubt an exaggeration, but it captures the fact that one person's gain is in some senses everyone else's loss. And we justify that loss of general freedom on the basis that secure private property rights encourage investment and innovation and long-term care of assets, allow markets to function and capital to be allocated, and they create a protected private sphere in which individuals and families can live flourishing, autonomous lives. All that may be true, but it doesn't tell us who should get these assets or what shape the rights surrounding them should take. And in that regard, Lawrence Becker's questions or Amartya Sen's questions or any number of philosophers' questions are useful here. For any given resource, we should think about whether priority should go to the finder, the creator, the person who can use it most productively, the local community, the state, acting under some democratically chosen principles of fairness or efficiency, and equally importantly, what kinds of property rights are appropriate. We should be a bit more structured and focused in thinking about our assets. We're not choosing between absolute perpetual ownership and no property at all. We already know how to vary duration and scope and burden. So the incidents of ownership are contingent design choices, not fixed natural facts. So on those design choices, secondly, and at a very high level, there are three decisions to be made. What can be owned, which I'm not going to talk about again, but who owns it and on what term. So if we decide that certain resources can and should be owned, they're excludable and they should be treated as property, then who should own them? Once a resource is in principle capable of ownership, we still have to choose whether it's held by the state, by community bodies, or by private owners. And that choice reflects judgments about what will best secure both effective use and the public interest. So we have national parks, public infrastructure, major cultural collections as examples of state or quasi-public ownership. Other assets are privately owned but heavily overlaid with public obligations, so listed buildings, environmentally sensitive land, for example. So having decided where ownership is best placed, then thirdly, on what terms should private ownership be held? We tend, as I said at the beginning, to talk as if private ownership conferred a simple triad of use, enjoyment, and power to transfer in pretty absolute terms. My plea is that we broaden that focus. Private ownership is justified because it serves a productive, thriving society. And that very justification supports constraining use and enjoyment and transfer if that's necessary, big if, but if that's necessary for the common good. That might mean limits on use, planning, environmental controls, nuisance, or on transfer, controls on land, cultural property, financial collateral, or the imposition of positive obligations to maintain, repair, disclose, refrain from harmful exploitation, etc. We already do all this, but in a highly piecemeal way. Landowners, chattel owners, holders of contractual and statutory intangibles all face different clusters of duties and limits. And on top sits an enormously complicated statutory patchwork, sector-specific regimes for financial services, housing, body parts, illegal drugs, each reflecting a different view of what ownership should allow and restrain. But unless we're clear about the point of all these interventions, we risk just a growing, elaborate regulatory system which covers some assets excessively and some assets not at all. So, thirdly, in considering what sorts of constraints might work more effectively, I appreciate there's a growing academic interest in stewardship model of ownership. I confess I'm really quite wary of any generic approaches to complex areas of law, property included, but I'm especially wary of a word like stewardship, which seems that it might implicitly suggest turning every owner into some sort of universal fiduciary. I think that would be neither workable nor necessary, but some modest claim might be workable, might even be unavoidable, if we're going to justify private property on the ground that it serves individual and social welfare. then perhaps owners could properly be required to manage their assets in a way that does not unreasonably damage the interests of the general population. It doesn't deny private property and its enormous advantages, it simply shifts the emphasis from a purely rights-based picture, this is mine, keep off, to a more balanced view in which rights and responsibilities are two sides of the same coin. Then I have to close on a note of realism, I suppose. The pattern of property regulation is now vastly more intricate than that for personal rights, I think. No single theory is ever going to give us a blueprint for all the layering of rights and responsibilities that's required. There is no simple taxonomy, no neat 3x3 grid that captures and answers all the problems. But the message that I really want people to take away from this lecture is that property law is not just a sophisticated organisational structure for the control and circulation of private wealth. That's not its focus. It has to be regarded as a framework for allocating responsibility for how resources are used and conserved and transmitted. That means that the property categorisation and all the consequences that flow from it, every time we have an opportunity to think about it, should be thought about as embodying something that's not a value-neutral choice. It embodies a decision about what we value and how power over those resources is best allocated and restrained. So I would like my triad of rights to enjoy, rights to transfer, and the incidence of obligations to be seen not as absolutes or not as incidents of ownership, but as levers, policy levers which can be used to deliver the ends we desire, provided we recognise and put more force behind the view that with rights of private ownership come responsibilities, in some measure, not to harm the common good. So what I'm trying to do is land in a place that's squarely within where the law is at, but also trying to articulate, or I will in the book at least, try and articulate or identify some slightly clearer structure which binds these crucial pieces together into a more coherent whole, so we can provide some sharper focus for the difficult future judgments that need to be made by the courts and by the lawmakers. So it's probably no different from what I've always done, but just a lot more complicated. So with that, I think I've only got one further thing to add. Although all these lectures are about property, and it is fascinating, and the possibilities and paradoxes I find endlessly intriguing, the real purpose, as I've said each week of these lectures, is to determine how we protect valuable resources for the good of us, for our communities and our world. So in a sense, it's really all about people and their significant relationships. And that's a great place to be. Thank you.
Wow, goodness me, Sarah. That was an absolute tour de force. I mean, it really, really was. You probably saw me scribbling frantically at various points because, the things I've written down here, power and protection, the third dimension of property, this dissection of excludability, a magnificent discourse on crypto assets. I mean, absolutely fabulous. And then I think concluding with a hopeful manifesto for how to think about property, not so much in terms of I have and you haven't, we, but kind of this sense of responsibility about how we share and use assets. I mean, I can think of really no other way of thinking in a hopeful, positive way about this most fundamental of topics. I mean, absolutely tremendous, Sarah.
You could turn around and sound beginning to sound like the 14-year-old who first heard about the LSE.
Oh.
It's far too idealistic. But anyway.
I think in the world we're in, this is, I do take this sort of sense of hope, Sarah, very strongly from this. I mean, wonderful. We have maybe about 50 minutes or so. I would prevail on Sarah for some questions. colleagues, who would like to start really to prolong these wonderful theses that Sarah has laid out for us? We have roving mics. If you just want to catch my eye.
Or we could all just...
Or we can all go, yeah, exactly.
Yes.
But no.
We could talk to each other about stuff not proper.
Andrew, so the Dean of LSE Law School, Andrew Murray, so we bring the microphone up to the who is a huge expert in AI, so I wonder if that's where this is.
Well, in some ways, it's showing the limits of the knowledge of being the technical digital lawyer in a sense. I mean, I completely agree with your destruction, shall we say, of crypto assets, or your analysis of crypto assets. But I wonder if we are to have this valuable resource that people are to invest in, that people are to believe in, is it part of the role of the law and property law to recognize and protect the investment element? Because it seems to me that the courts in England and Wales, at least in part, have been led to kind of down a property pathway because almost people are turning up at their doors saying, I've got a lot of money in this, and if you don't help me, the whole edifice collapses. So should the law have any interest in or care about the commercial world, or should the law be purer than that and say property, as you're saying, has to have these characteristics?
Maybe the answer is pretty much the same as it is with all sorts of property, that the way the law should treat it is different depending on whether the reason you invested in the crypto was because I fraudulently induced you to invest in this absolutely valuable resource, or buy my black dog, or my, only one careful driver car. But actually, what we're remedying then has got pretty much nothing to do with property. It's got to do with my behavior towards you. So there's one aspect where we could be protecting people from investments in things that don't have value. So I think the law can do that and should do that. But I think it's a different thing when you think about people who voluntarily put their money in, I'm going to invest in some startup that could earn me 2 million, or it could lose me all the money I've got. We have rules about whether I've made that decision appropriately or not, but if I've made it properly, then, and I think quite a lot of the aspects of crypto where you're talking about people who've gone in a properly, decided way into the crypto club, you're talking about those sorts of people, and I'm not sure that, I think it's quite difficult to protect them within that framework. And whether we should, I'm sure.
There's a question at the back, but there was so much richness in the lecture, but I can see the crossovers with regulation and this really kind of interesting intersection. I think I see Professor Braithwaite at the back.
Hello, thank you so much, Sarah. So as we know, English law is used very broadly in all sorts of contracts and transactions that have nothing to do with the jurisdiction and no parties connected to England. And that comes through very strongly in some of the debate around how the law should develop in relation to crypto assets. So my question really was whether the sort of direction that you're advocating today is compatible with sort of the development of English law as a sort of product or a sort of competitive feature of the jurisdiction, and the interest in maintaining that workability for all sorts of users worldwide.
I think that's a really good question. I can remember when I think it was Tulip Trading went to the Court of Appeal, and it was really does the court have jurisdiction to hear a particular claim? And it was about developers being fiduciaries, so I got interested in it. And I thought the arguments that were given for the court for this claim to be heard were not particularly strong. But had I been one of the judges on the Court of Appeal, I would have certainly wanted heard in the courts in England. So I would have found the reasons, if I had been a judge, I would have found the reasons to enable this to be argued properly in the English courts. So I think the English courts must be in the game But then it's a question of how they should be in the game, isn't it? And I think what the Law Commission has currently proposed and the government seems about to do is really to say, this is all terribly complicated and we're going to leave it to the judges. And that means that we're going to depend, I know we're likely to have a lot of cases, but we're going to leave it to a case by case, which is not the best way to have a nice framework of something that's complicated. And you contrast that with what we did with intellectual property, and those statutes no doubt get amended from time to time, but at least you have a starting point where you think this is what we're looking at, this is what we want to protect, and this is why we want to protect it. And outside those boxes, so far, we're not going, but, you know, if you're in that, you know, if you're within this framework, this is what you get. And I think I would advocate we did that. And some things I would put outside the box. I mean, it's a bit like the person whose hard drive is on in a tip somewhere, and I don't know where it is, but so he hasn't got his private key, but he's missing, I don't know, you read reports, 600 million, nearly $1 billion in Bitcoin that is, you know, on this distributed ledger. So he hasn't lost his asset in one sense. He knows exactly where it is. He's lost his key. But the only problem is, you know, because these platforms are organized the way they are, no one can give him a duplicate key. And of course, no one's taken his asset, so he can't sue anyone in conversion. So there he is, he's stuck, he's lost his assets. Well, with the best will in the world, what could the law do about that? You know, I've lost my dog. I've lost, you know, it can't find it for me or get it for me, can it? And I'm not sure that we have the power to compel a duplicate key from a system that's designed to operate outside the law and not be subject to any legal regime. I mean, we find it hard enough when we break the passwords on Apple's phones and that sort of thing.
Like bear a bond. Rescue team. And colleague in the third row front.
You, Ben?
Oh, thanks. Just to change the subject slightly, I was really interested in what you were saying about the responsibility aspects of property. And as you said, there are some responsibilities that everyone's under, as to how you drive, for example. But I can see the idea that there's specific responsibilities that only owners would be under. So the ownership would be used to identify them as those having those responsibilities. And I suppose that's quite limited in the law at the moment. And I wonder whether you think there's a tension in the sort of transferability of property, so that if people can transfer property freely, we don't know who's going to be the owner at any point, and therefore we don't necessarily know that that's the best person to discharge the responsibility. So I wonder whether there's a possible tension between the role of ownership in allowing transferability, and then also wanting to use the idea of the owner as bearing a special obligation, because we don't know necessarily whether that person is the best person to bear that obligation. And if we wanted to impose obligations in relation to particular activities, alternatively we could do that directly and not filtering it through property and ownership. So I just wondered if you think there's possibly a tension between two of those three fundamental elements.
I'm not sure if I can unpack this in quite the way you put the question. That would be my inability, not that I didn't understand the question. But it's true that if we impose lots of obligations on owners, then we make the property, in a sense, more sticky in transferring it to anyone, partly because you don't want to take on ownership, do we? So you've done work on, you know, all the Grenfell fallout with buildings. Well, you've made buildings really, really sticky in, you know, having to have all sorts of certificates about their fire safety, etc., for transferring them. So I understand that bit about it, and there's some, I mean, that's perhaps a good illustration where there are positive obligations imposed on the owners, not just restrictions on what you can do. And the restrictive side of property ownership, it seems to me, is much easier. So it doesn't really matter if it's someone rich or poor or someone capable or incapable. You say, sorry, you're not allowed to do that, you know, and it's not making them pay for something they can't afford. So I do see that difference really quite dramatically. And I think then it depends what sort of asset it is. And we might decide, say, for listed buildings, you know, sometimes they can't stay in private ownership because they can't be maintained by the people who own them in the way that the listing requires them to be maintained. So yes, I get all of that. And now I've forgotten what the third bit was. I'll pick it up with you later.
Oh, fabulous. And Sideburn.
Hi, thanks a lot, Sarah. I really enjoyed it. I also have a question about the 3 sticks you picked up from the bundle. About the 3 sticks you picked up from the bundle. I wonder whether they sit well, or you can explain more how that works with the increasing trend we see towards shared economy and shared property. I'm particularly worried, of course, about the first excludability stick, and whether that accounts well for what we see around us in terms of a lot of shared property and shared
give me an
ownership.
example of the kind of sharing that you, that's the shared property. While you're thinking about it, let me give you an example. So, I don't now remember which lecture I did this in, but there was one of the lectures I was talking about assets that we say are not owned, like, you know, the fish in the sea, or sea itself, or water in rivers. So we can have assets that are not owned, but we can impose lots of obligations on people about taking those assets for their own use, and about how they use the asset and what damage they cause to the asset. So in some senses you could say, even though they're unowned, they're also assets which are shared, aren't they? You live on the bank of a river. You don't feel as though it's got nothing to do with you. You do feel as though you've got some asset that you're privileged to be able to use. So the sharing like that, and it reminds us that there are different ways of managing assets that we want a lot of people to have access to benefit. So there's that kind of framing. I think where I worry even more is some of the assets we really, really care about are global. They're not, you know, I sort of talked about only national boundaries, implicitly talked about only national boundaries on all, but, you know, the air we breathe, that kind of thing, is not a national problem. It's an international. That kind of thing, top 30. I mean, where we're going with that is really difficult to see.
Lydia.
Oh, yes.
Maybe let's not even go there, but, you know, you think about how we think about it. Potentially. Give me a whole other way of thinking. So I think we might be moving. Brilliant, Sarah, but
I can go.
another colleague on this side.
Oh, no.
Well, first warning, you should never speak about crypto. As soon as you've done that, that will be all anybody else will want you to talk about ever again. So, not asking you about crypto, about responsibilities.
Yeah, okay,
so
good.
I can see that if you have title to land, that carries with it certain reciprocal obligations. So that if a fire starts in my home without any fault of mine by a lightning strike and endangers my neighbour's property, I've got to put that fire out in a way that I don't have to do ordinarily. I'm suddenly under these positive duties because of my ability to exclude people from the thing, then creates these positive duties on me which don't otherwise exist. Can we think of examples of that phenomenon outside of rights in relation to things? So on your list you've got contracts, information and ideas. So can the fact that I've got a contractual right impose upon me a reciprocal obligation? Or the fact that I have a patent or a copyright or some other form of intellectual property right, can that impose upon me reciprocal obligations to others? That's my question.
That's a really good question. And I think, you know, the property side of restrictions is not just land, is it? You know, you need MOTs for your car and all that kind of thing. So, but what we do with contracts, I think, is a bit different and really quite interesting. And I hadn't thought about this at all in the property context. But when you think about trying to enforce contracts in the core, there are restrictions on what we're allowed to extract from the people that we're contracting. And I think you were at the obligations conference where I talked about the idea that it's all very, we often say that, you know, these contracts are binding and your damages will give you the money equivalent of performance. But in fact, the courts don't give you the money equivalent of performance. They make you mitigate, they review terms, they say what things can't be enforceable. And it seemed to me, after a lot of thinking, what I floated was the idea that, in fact, the courts don't care whether I get the apples out of a contract for delivery of apples at all. They couldn't care less whether I got my apples or the money equivalent of apples. What they care about is that we have a contracting system that works reasonably fairly for everybody who's in it, no matter what side they're on. So the rules about what's enforceable and what you can claim in damages and whether you can get injunctions and whether you can get specific performance all operates a bit on the, you know, regardless of which side you were on, would you think this outcome was fair? So not exactly what you agreed, notwithstanding you went into it with your eyes open. And I think that's the limitation, not the equivalent of having to put the fire out, but it's a restriction on exactly what rights you get. But it's pretty limited. A much, much more limited one than operates with property that exists in the world without a legal framework as its beginning. I agree.
Absolutely tremendous. I mean, it genuinely was a tour de force, and done with your trademark precision. The argument worked. I found it absolutely wonderful. No pressure. This book, very important. We need it soon. I just want to bring us back to Emma Hamlyn's request for just a second. I think it's very important. She was a non-lawyer, and she introduced this trust for the wider education, obviously, for the common people. And I think what's so important about your lecture, Sarah, is you've given us subtlety, you've given us this huge intellectual, I think, kind of vision of property. But I think in issues that matter, in terms of how we live our lives today, whether it's crypto or the commons or, you know, water and resources. So I think it really resonated with me in terms of being an actual real life set of problems. But secondly, Emma specifically said the responsibilities and obligations. I think thinking about property the way you have, you've really brought out that public dimension about the important choices we make about responsibility. Property.
Well, I'm glad I didn't cause the trustees to be in breach of trust.
So can I first of all thank Giuseppe and the LSE Law team for putting a fantastic event together with their trademark, a superb professionalism, in particular the Hamlyn Trust. Thank you so very much for a wonderful evening. But most of all, our spectacular Hamlyn Trust lecture. Sarah, thank you so very much.